This is State of Wisconsin versus Russell Rose Jr. The file is 14 CF 1362. Appearances, please.
Good afternoon, Your Honor. The state appears by District Attorney Robert Zaff.
Russell Rose Jr. appears in person and with Attorney Eileen Henry appears as friend with the court. Good afternoon, Your Honor.
Good afternoon. Ms. Henry, on behalf of this defendant.
I do acknowledge receipt of the criminal complaint and I waive its reading.
All right. Mr. Zaff, with regard to bond.
Appeal.
Thank you, Your Honor. With regards to bond, I would inform the court that the defendant, according to my information, is under a probation hold at the present time. He's not a newcomer to the criminal justice system, has a prior criminal record. He has a conviction for delivery of a lookalike substance in 1996, resisting obstructing as a repeater in 1997. He has 4 convictions growing out of a file in 2000 CF 233 on December 15th of 2000, 2 counts of which involved escape. 1 count involving an escape, 2 counts involving resisting as repeaters, and a battery to a law enforcement officer as a repeater. In 2008, he was convicted in Kewanee County. I believe that's where he might have been institutionalized in a facility of another count of escape. My count is he has 7 prior convictions, 2 of which involve escape. With regards to the present charges, he's looking at one of the most serious crime on our books is first-degree intentional homicide and a very aggravated, tragic death of this young 11-month-old child. The court has had the opportunity to review the complaint and sees the other related charges of aggravated battery, strangulation, false imprisonment, arson of the building, and first-degree recklessly endangering safety. My computation of the potential exposure would be life plus over 70 years of incarceration. For all those reasons, Your Honor, at this time the state would be asking the court to impose $1 million cash bond. I would also indicate in the 4 corners of the complaint it is expressed that the defendant expressed to others that it was his intent to kill the child.
Thank you. Ms. Henry.
Thank you, Your Honor. He is 34 years old. As the state has mentioned, he does have a record, and because of that, he is on appeal hold. He's lived all of his life in Kenosha. The case on which he's on appeal hold, I believe he's facing at least 10 years of initial incarceration, so I would ask you for moderate cash.
Well, I've been doing this kind of work for over 40 years, and never have I seen a more aggravated, heartless, and cruel and inhuman case if the allegations against this defendant are true. This is a case of brutality of a child and of a mother. The description of the defendant's conduct in the criminal complaint, the sheer brutality, is almost incomprehensible to this court. The description of the injuries suffered by the child, by the doctor, and also the injuries by the mother presents an overwhelming case of brutality and cruelness by this defendant if these allegations are true. The evidence, according to the criminal complaint, is overwhelming. He's got 7 prior convictions, including 2 prior convictions for escape, which makes him a very poor risk for a signature bond or a low cash bond. The potential penalty, as indicated by Mr. Zaff, is apparently over 7 years plus life, and he's facing the potential of life without parole. All these things would tend to cause him to not appear in court, and also the very nature of this case, the magnitude, the dangerousness of his behavior requires, if not screams, for a cash bond. Bonds can be set in the amount of $1 million cash. Mr. Rose, you are entitled to a preliminary hearing, sir, within 10 days of today. The attorney indicated to me that you're willing to waive that right to have it within 10 days. Is that correct?
That is correct.
Anybody promise you anything or threaten you in any way to get you to agree to do that?
There's no promises or threats against me.
You're waiving this after discussing the matter thoroughly with the attorney?
Indeed.
I'll find that he is freely, any objection by the state?
No.
I'll find that he's freely, voluntarily, intelligently, and with the advice of counsel, waived his right to a speedy preliminary hearing. We will set it outside those times.